of the Southlands Affordable Housing Project. In summary, he seeks declarations that the project and the approvals issued in relation thereto violate the Constitution, the NEMA, and the PLUPA, particularly in relation to environmental safeguards, zoning, land use regulation, and public participation requirements. He further seeks declarations that the sought property was unlawfully converted from public utility land to private development, and that no EIA license or development approval should issue absent full compliance with constitutional and statutory requirements, including meaningful public participation and stakeholder consultation. The petitioner additionally seeks orders of certiorari, prohibition, and mandamus to quash and restrain the impugn approvals and development activities, compel compliance and revocation of approvals, restore and rehabilitate the environment, and permanently restrain further implementation of the project pending compliance with the law. The court vests this court with broad remedial powers in proceedings brought for the enforcement of fundamental rights and freedoms. Article 23 of the Constitution provides that in proceedings brought under Article 22, the court may grant appropriate relief, including declarations of rights, injunctions, conservatory orders, declarations of invalidity, compensation, and orders of judicial review. In light of the findings made herein, and having considered the pleadings, affidavits, evidence, and submissions presented by the parties in totality, the court is satisfied that the petitioner has partially established the petition dated 4th of July 2025. Consequently, the petition is partially allowed in the following terms. A declaration be and is hereby issued that the respondent's actions and omissions in approving, facilitating, and proceeding with the impugned development violate the petitioners and other residents' constitutional rights under Articles 10, 42, 47, 69, and 70 of the Constitution, as particularized here under Roman 1. A declaration be and is hereby issued that the 1st, 2nd, 3rd, 4th, 5th, 7th, and 10th respondents, by approving and implementing the impugned project without lawful adherence to statutory and environmental safeguards, have violated the Constitution and the Environmental Management and Coordination Act by failing to conduct a proper environmental impact assessment and obtaining an EIA license before commencing construction. Roman 2, a declaration does hereby issue that no environmental impact assessment, license, or approval shall be issued in respect of the Southlands Affordable Housing Project unless and until there is full compliance with the law, including A, meaningful and effective public participation as captured in this judgment. B, obtaining the approval of all lead agencies in accordance with Articles 10, 42, and 69 of the Constitution and the provisions of NEMA. C, conducting a comprehensive environmental and social impact assessment and an EIA license from the 10th respondent. B, that is capital B, that's the second order. An order of certiorari does hereby issue quashing EIA license number NEMA/EIS/PSL/0001425 issued on 16th of December 2025. Capital C, an order of prohibitory injunction is hereby issued restraining the respondents, their agents, employees, contractors, developers, or representatives from commencing, continuing, or undertaking any operations or construction activities in relation to the Southlands Affordable Housing Project, famously known as the Southlands Affordable Housing Project, pending full compliance with the law, including, but not limited to, A, meaningful and effective public participation as captured in this judgment. B, obtaining the approval of all lead agencies in accordance with Articles 10, 42, and 69 of the Constitution and the provisions of NEMA. C, conducting a comprehensive environmental and social impact assessment and obtaining an environmental impact assessment license from the 10th respondent. Capital D, that's the final order, each party to bear its own costs given the public interest nature of the petition. So that is the judgment of the court, which runs it 128 pages. We are going to upload this judgment in the next few minutes, so be on the lookout probably the next 1 hour. We'll have uploaded it so that you can read the entire judgment and get instructions from your clients. Thank you very much for listening to us.